Brahma, Assistant Professor in Velachery, Department of BCom Bank Management, Guru Nanak College, belonging to the School of Management. Today we are going to discuss the topic, essential elements of a valid contract.
First of all, what is an agreement? An agreement is an offer plus acceptance. You have heard of social agreements, domestic agreements, legal agreements. What do you mean by a social agreement? The agreement which has been entered into between friends or between a husband and wife, all these things are called as domestic agreement or a social agreement. Probably you've agreed with your friend to attend a party in the evening, but you don't turn up. Will your friend file a case against you? No, it's not possible because it's a domestic agreement. Only legal agreements are enforceable under the contract. We are going to discuss about what is a Contract Act. The Contract Act, according to the Contract Act, and it is a private law. Why it is called as a private law? Because it binds only the parties to a contract, which is called privity of contract. So, supposing if A and B enters into the agreement, it is only A who can file a case against B, or B can file a case against A if something happens wrongly. It is not C, who is a stranger to a contract, who can file a case against the parties. So, that is why it is called as a private law, and it applies to whole of India, including Jammu and Kashmir. What is a contract? As I told you, only legal agreements can be termed as contracts. Section 2 of Indian Contract Act 1872 has defined a contract as an agreement enforceable by law. So, not all agreements are contracts, it's only the legal agreements which can be called as a contract. So, as I discussed before, agreement is equal to offer plus acceptance. There should be two parties, one party offering, the other party taking the offer and accepting it. So, agreement is equal to offer plus acceptance, and contract is equal to agreement plus enforceability at law. There are 9 essential elements of a valid contract, which we will be discussing one after the other. First one is offer and acceptance, next intention to create legal relationship, next lawful consideration, capacity to contract, free and genuine consent, lawful object, agreement not declared void, certainty and possibility of performance, and legal formalities. To begin with, the first one, offer and acceptance. There should be proper offer and proper acceptance. That is, there should be two parties first of all, one party offering, another party accepting the offer. And the offer must be definite. For example, if A is having 3 cars, and if he says A is offering 1 car, he has to specify which car he is offering. So, the offer should be definite and not vague. Not vague meaning it has to be clear, which is offered by A has to be clearly communicated to B. And acceptance should be unconditional. That is, there should not be any condition based on which acceptance is given. If you supposing if there is an offer saying that A offers to sell his house to B for 1 lakh, and B says if it is given at 90,000 I will accept it, then it is a conditional acceptance. Acceptance should not be conditional. Acceptance should be according to the mode prescribed and communicated to the offerer. So, if the offerer has asked the acceptance to be communicated through wire, that is call and confirm, it has to be called and confirmed, and the offerer has to be communicated, that is acceptance has to be communicated to the offerer. The second essential element is intention to create legal relationship. That is, both the parties should have the same mindset to create the contract into a legal contract. For example, in this case law, Balfour versus Balfour, a husband promised to pay his wife a household allowance of 30 pounds every month. Later, the parties separated and the husband failed to pay the amount. The wife sued for the allowance. Now, is it first of all a legal contract? No, it is a domestic agreement. So, the judgment was that the agreements these are outside the realm of contract, and hence it cannot be called as a contract at all. So, it could not be enforceable. The third one is lawful consideration. For anything, there should be something in return. Whatever you give, you have to take something in return. For whatever you have taken, you have to give something in return. Same is applicable for lawful consideration. So, there should be some advantage, a benefit, or something moving from one party to another. In return, he should be getting something. That something is what we call it as consideration, and the Latin term from which it has come is called as quid pro quo. And the consideration has to be lawful and it has to be real. It need not be adequate. It need not be equal in amount to whatever has been taken from the other side. And it may be in cash, it may be in kind, or it may be an act. Doing something is also consideration. See, giving a book to my friend for studying for exam is a consideration. The same way, taking a cycle from my friend for my own use, that is also a consideration. And it may be past, present, or future. It would have been got in the past, or it might be got in the future, or it might be done at the same time. So A agrees to paint a picture and B agrees to pay for the same. Both happening at the same time, that is also consideration. The next essential element is capacity to contract. Here, who are the persons who have the capacity to contract? The major, that is one who has attained 18 years of age, one who is a sound-minded person, one who is able to analyze and understand things and is able to judge or decide whether to enter into a contract or not on his own, is called as a sound-minded person, and he should not have been disqualified from law by any law in force. So, the persons who have incapacity are minor, unsound-minded person, disqualified by law. These persons cannot enter into contracts. The next essential contract is free and genuine consent. First of all, there should be consent. Consent means knowledge and approval of the parties concerned. Consent should not be obtained by coercion, misrepresentation, undue influence, fraud, or mistake, which means the consent should be given freely out of his own will, and he should not have been forced by another person to give his consent. Only then the consent is acceptable as far as the contract is concerned. There should be consensus ad idem, which means both should have thought about the subject matter in the same sense and at the same time. For example, A is selling, A and B is into a contract where A has told, I am ready to sell Hansraj to you, but he has not specified the name. But B is thinking that A is offering Rajhans. In this case, A is actually offering Hansraj, whereas B thinks it is Rajhans. Both the horses are totally different one. This is A, horse A, then that is horse B. A is offering horse A and B is thinking A is offering horse B and giving his acceptance. Here, there is no consensus ad idem. Each one is thinking in their own way. In this case, that cannot be called as a contract. The next essential element is lawful object. There is the object or the purpose or the aim for which you are entering into contract must be lawful, legal, and it should not be opposed to public policy. A agrees to pay 500 to B if B beats C. This is very clear from the fact that injuring or harming another person is not a contract, it is against law. So, it is against public policy, so it is not a contract. Then the next essential element is agreement not declared void. That is, the agreement should not have been declared void by any act of any law. For example, in India, agreement with a minor is void ab initio. That is, right from the beginning it is void. You cannot enter into such a agreement at all. The next essential element is certainty and possibility of performance. So, the agreement should be certain and capable to perform, and there should be possibility of performing the contract. Here, A agrees to sell 100 tons of oil to B. Here, what is that 100 tons? What quality? Is it Agmark A, quality 1, quality 2? What is the rate? Nothing has been specified. This kind of contract cannot be entered into for void of certainty. It is not certain, it is not clear. The agreement to do impossible act, that is giving life to a dead person, it is not possible, it is again void. To end up with, there are legal formalities which has to be gone through. For example, certain agreements must have to be signed, certain agreements must have to be stamped, certain agreements must have to be registered. If supposing all the other essential elements are there, but the stamp alone is missing, even in that case, that contract cannot be legally enforceable because it is lacking due to legal formalities. So, all these 9 essential elements are very, very important in order to an agreement to become a contract. So, these are all the essential elements of a valid contract: an offer and acceptance, intention to create legal relationship, lawful consideration, capacity of parties, legal formalities. The agreement should not have been declared void, and there should be certainty and possibility of performance. The object must be lawful, and there should be free consent. That's all for the day. Thank you, friends. Okay.
Madam, Right.